Peace FM 104.3. Good to meet you.
That Okaya or say, according to the literal language of Article 146, no one is required to examine a petition brought against the Chief Justice to ascertain whether it establishes a prima facie case before the President refers it to a committee established by him. Once any petition, no matter how frivolous its contents are, is presented to the President, then he has a duty to establish a committee to consider it. A literal reading of the provision, therefore, could lead to the floodgates being opened for frivolous and vexatious petitions being continuously filed against a serving Chief Justice, with two Supreme Court judges being perpetually tied down to hearing such petitions alongside the members of the committee that the President has to appoint. This is a scenario that would weaken the efficacy of the top echelon of the judiciary. And this is what President Mahama did. Dr. Dateban, Professor Dateban.
So what was his remedy?
Was being prophetic.
What was his remedy for that lacuna?
And you say, there is even more mischief in a literal interpretation. This is because Article 14610A authorizes the President, albeit on the advice of the Council of State, to suspend the Chief Justice whilst a petition for its removal, in this case her removal, is being considered by a committee appointed by him under Article 1466. There is thus scope for the executive or others to initiate frivolous and vexatious petitions against the Chief Justice, resulting, according to the literal reading, to an automatic establishment of a committee to consider the petitions and the empowerment of the President to suspend the Chief Justice from his or her functions. This is a scenario that is deeply subversive of the balance of power underlying the 1992 Constitution and the separation of powers that it entrenches. It is, of course, also inimical to the independence of the judiciary, as the plaintiff points out in his statement of case. Oma issues are, and Obeka say, yeah, kind a constitution now. Yeah, just say, yeah, in literal meaning, no qua. And or can be say, Article 1466, no, yeah, no say, as I say, you establish a prima facie. Chief Justice, there, no, to say, 3 and 4, you establish a prima facie on any other justice of the Supreme Court. Samrei, ye mungu ye nane no. There are 5 cases at the Supreme Court currently, including one led by Census. I'm here, interested party.
Census,
Center for Citizenship, Constitutional and Electoral Systems.
Okay.
Challenging the constitutionality of the process. Yaka say committee now na mampani say why no. Omo ntwen so ma yendi asem no because anytime can set up committee no kra no. Supreme Court ya anya adwene. Omo say remedy anu ye na ye pe no. Committee no ebetimi aso ano. Ye di akire. The committee refused to address the issues that we raised because committee na ankasa no ya manum rabia na guide no ono na choose CI 47 e the guide no again the Supreme Court in many judgments aka say Article 146 committee no ese say ya manu nhihye ya odi be ye na twuma cardinal enwie ho adanse ani kwadu a ye say ye de abo maame no ye say ni kunu ene ne ba ene ne tu kwan na judicial service ema ni kunu ene ne ba no sika ye de ho sobo ebo no emra ejina so de me meti aminim one ma ebusa se mra ben na sa process yi we call it a phony trial ase yesu ye pena kunu na Adanse for crime against Roman and Jewish law. I can say, ye dear same cry judgment beba not less than 48 hours. But the trial of Jesus Christ took, and in the execution, it took less than 18 hours. 1 day crime. The NAIN. And only a friend of Kangaroo trial, Kangaroo court.
Why will you make that conclusion?
I made that conclusion because of the conclusion the President has come to. notwithstanding challenges of the ill-informed process he was on.
When the 146 I can't say the recommendation about president ma onye ho hwe no.
You see, and then I can say bibi hyase and say na yakoduru ba bia ye wo no. Enti enam saa sin tonunti ene ye ka say enam say saa committee owie na dwuma e cheche wo president wo santi. Say ahyase no wo fum twa wo be fum aku. Anaso wo be wo fum dua wo be fum atwa. Enti mfomso na dikan abade a yenso ano ne yensiesie kra asa na yato aso. Yesi hey yentiase ye manum koso ana yakoso ne yakowie se sesi ayi no asemu a eda court a enum. And I can tell you ana no me ma me lawyers e ma ye search wo court Supreme Court registry cardinal nukura wo ni say attorney general onye na adwene kura say obe file responses to statements ya file onye na adwene say obe me di asem no obetma file excuse say there's a legal vacation so time is not counting, but asem yi shall say June, legal vacation shall say August, June, July, 21 days na elapse. Enti bibia kire say ya adwene me trust you hana me kan say ade no de wa asi aye no now hwe say maame na no ye ode come president achi president say we push a committee na committee no asenko pa o mu kokko investigate kra no ana prima facie president establish here no on come yente into okoso na omo aye de oye no na it only concludes say ye see adwene pi ye wie de ye pese ye na mom ye pese ye ma na ye te se de ye de mra na ye sa pepepe na wonim de ntia former chief justice Sofia Akufo ni buafu no David ana de I koso ne bonyo so no so ono why ye what the 146 no in 2017-2018 what now committee so or establish a prima facie. Okay. In the case of Mame Charlotte say okay George Nopokwa Mankwa any Alhaji Amadou Sule na me fa ne currency na ahobrasem cardinal womo mu de Charlotte say din ayetwe apia e de yem fanto we no let me tell them Charlotte say started the process for her removal, prosecuted the process for her removal, and so she thought say no betimi ayi ni deputies no na ka ono nko. She fell on her own dagger, and I prove to you here. Do this is the file that I concluded on Amadou Sule. Nipa no de animu no ye
Peace FM 104.3 Would you mean